Broadcast is now starting. All attendees are in listen-only mode.
Hi, and welcome to the very first in our series of divorce webinars that we're going to have over the next several weeks. My name is Jacki Roessler, and I'm going to be presenting to you on the Gray Divorcée, what Michigan women over 55 need to know when they're getting divorced. And this has been a very popular topic of late because our average divorcing age has been going up recently. And this affects many more people, and we've gotten a lot of requests for information on it. So a little bit of background on me. I'm a certified divorce financial analyst. I'm a financial planner, but the only cases that I work on are cases that are in the process of or post or contemplating divorce. And that's what I've been doing for the past 20 years or so. Actually, I've been a certified divorce financial planner and since 1992. So I've been doing this for a very long time. And it's something that I have a lot of passion about. And I also do a lot of presenting for lawyers and judges on all kinds of topics related to the financial issues of divorce. So just a few housekeeping items before I get started. One, if you have any questions, all the chat features are disabled in this presentation. But please send me an email, and I'm happy to respond to any specific questions that you have. Also, please visit our website for blogs and any upcoming webinars that we have on divorce or other very interesting financial planning topics. And you can visit our website. Down below is the address, www.centerfinplan.com. So we have a lot of material to cover, so let's get started. What is gray divorce, and why is it different than regular divorce? Why are we even talking about this issue? Statistics show that a large percentage of new divorce filings are people that are over the age of 55, and since people are living a lot longer, we have a lot longer period of retirement. And for someone who's getting divorced, they have come up against many different types of issues that a young person getting divorced who may be more concerned about the marital home and parenting time of minor children than issues of retirement. One of the main reasons why gray divorce is different is that there's less time for both parties to recoup their losses. So for most cases, the majority of cases in my state, which is an equitable division law state, are going to settle 50-50. In other words, both parties are pretty much going to walk away with 50% of all of the assets and debts that accumulated during the marriage. However, so when we give up 50% of all of our assets, we have to rebuild. And when we're talking about someone who is getting close to retirement date, they have a lot less time to recoup those losses that they experience when they get divorced and lose a percentage of their net worth. Also, we have longer life expectancy. So we used to retire, and people would retire on average at 65, let's say, and they would plan to be in retirement in that period of their life, maybe until they were 80 or 85. Nowadays, we're living a lot longer than that, so our money needs to last a lot longer, but we're still have not been adjusting our retirement date. So we've got pretty much retiring at the same amount at the same point in time, but we have that money again needs to last for a longer period. Why does that affect women more than men? Why am I presenting this seminar for women? I work with both women and men in the process of divorce. But women on average earn less than men. And on average, that means they have less employee benefits than men if they earn less. So they've got maybe more healthcare concerns and how to cover any healthcare costs and healthcare gaps. And we live longer than men do. So our money has to last longer even if we're the same age as our spouse. So I'm going to show you, I always think the best way to walk through with clients or attorneys any financial topic is to use a case study. So this is Karen. And Karen is not a real client. She's not a real person. She's a real person out there on the internet somewhere. But this is just one of those a picture that we downloaded. So this is Karen, and she has her she came to us, and she's very typical of a lot of clients that I'm working with at the moment, actually. Her big concerns are healthcare, retirement income, Social Security, and fairness, making sure that she and her ex are going to walk away in a somewhat equal or equitable position down the road when it comes to a financial settlement. And these were her biggest concerns. So let's take a look at Karen and Bob. So Bob, also not a real person, but based on many real people that we've worked with. Bob is 57, Karen is 55. They've been married for 30 years. Karen had a master's degree in teaching, but she hasn't used it since before her children were born. They have 2 adult children who are 20 and 24. Bob is an employee at Ford Motor Company, where he's been employed since he was 30. His salary is $150,000 per year in base pay, and he's eligible for bonus income of $25,000 to $30,000 based on corporate performance and his own individual team performance. So let's take a look at Karen's first concern that she raised. And like many of my clients, when Karen sat down, Karen's not real, but based on many real people, the first thing that she was concerned about, in order to agree to a settlement, she wanted to make sure that her health care costs would be covered throughout her divorce. So generally, health insurance is a benefit of employment for the breadwinner spouse. Karen's been a stay-at-home. She hasn't been a stay-at-home spouse. She has not been out in the workforce. And even if she were to go out and get a job today, she hasn't used her degree in many years and would need to have some retraining. On top of that, very unlikely that she would get the same premium benefits that she currently has for healthcare as Bob's spouse. I want to talk a little bit about the impact of the Affordable Care Act repeal on the dependent spouse like Karen. Regardless of your political leanings, the Affordable Care Act has been very good for divorced spouses, and I'm going to explain why. Prior to the Affordable Care Act, if you were getting divorced, you were entitled to temporary coverage through COBRA for 36 months for the divorced spouse. So you could go on COBRA for up to 36 months. It was temporary, so it was not guaranteed to continue after that time period. And the premium payments are pretty expensive for COBRA. They're allowed to, we have clients where they come in and the COBRA cost is 150% of the premium payment that the company pays for the employee. So that might be $600, $650 a month. So it's not inexpensive coverage through COBRA. But it is coverage. It's also not guaranteed to continue. So let's say before the Affordable Care Act was in place, Karen developed a health issue in this 36-month period. She could end up becoming uninsurable and not being able to get continued coverage unless it was at a much higher rate with maybe even some items that were excluded or some issues. So we had concerns prior to the Affordable Care Act when clients were getting divorced that there might be one uninsurable spouse. And for a lot of people, this actually prevented them from getting a divorce. And we would have couples that would come in and say that they couldn't afford the divorce and they would consider becoming legally separated so that they would both would still be entitled to health insurance coverage, which doesn't always work anymore. Then, again, regardless of your political leanings, the Affordable Care Act has been wonderful for divorced spouses. Under the Affordable Care Act, you can secure private coverage for health insurance regardless of any pre-existing conditions. So we don't have to be concerned about someone developing a heart disease or cancer in the middle of a COBRA time period. Regardless of any pre-existing condition, ex-spouses can now obtain insurance. You also don't have to wait for a certain entry time in the year because the Affordable Care Act has a change in life event timing clause. So if I got divorced on February 1st and the deadline for me to get into a new policy, which is coming up soon, by the way, for people that are using private insurance, I don't have to wait till the next open enrollment period. I can get that immediately as soon as my divorce is final. It also has continued coverage for adult children to age 26. Whoops, need to catch up there. Continued coverage for adult children to age 26, which is often a primary concern for many of my clients when they have adult children is who's going to pay for that health insurance coverage cost. And the subsidies on health insurance premiums can be very large that people receive. So if the Affordable Care Act is repealed, we have to start asking the same questions that I used to ask years ago. One, clients like Karen will want to know, is divorce affordable for her? She's the dependent spouse. What if she can't get coverage? Or what if the insurance coverage that she can get is prohibitively expensive and doesn't allow her to have any liquidity for the rest of her cash flow? How will she be able to maintain the marital home? And that's going to be a big concern for many people that can't qualify for coverage. Also, we have to ask, will insurance be available at all for those with pre-existing conditions and no work history? Same situation that we were in prior to the Affordable Care Act. So it is going to make things more difficult on divorcing spouses if it's repealed. This is where a divorce financial planner can actually be very useful. Part of my job is to help my clients pinpoint any potential costs they may have in the future, like health insurance, and find a way to include that in their overall settlement. So if one spouse doesn't have health insurance expenses and the other one does, is there a way to compensate the one that does not? For some clients, continued health care insurance may not even be an issue. Perhaps they plan to re-enter the workforce. I have several cases right now, though, where the key issue for my client is affordable health care post-divorce. One is a cancer survivor, and if the Affordable Care Act is repealed, she's very concerned about her ability to retain coverage. For her, this is a serious impediment to finalizing her divorce. Her husband's covered by his employer policy. So our key problem to find a solution to is to find a way to compensate her that in the overall settlement, compensate her for that inequity. And if we can't do that, if there isn't any way to do that within the context of the settlement, my job is to prepare her to reduce her expenses in other areas of her life so that she can afford that health insurance coverage. I always believe that knowledge in advance of agreeing to any settlement is power. Even if you have information in front of you that proves to you that you cannot continue the same lifestyle that you had prior to the divorce, I believe that it's much better to know that up front before you sign an agreement so that you can make adjustments rather than being surprised 3 years down the line. And that, again, is what my job is as a divorce financial analyst. So let's move along. Karen's second concern was retirement income. How am I going to live in retirement? It's just around the corner for her. She's 55 years old. She knows that even if she gets a job, that she doesn't have the ability to go out and earn a pension or accumulate a lot of money in retirement assets. So she is concerned about where her income will come from. She's also very concerned about being able to afford her house. She wants to stay in her house, but she's not sure that in retirement she will be able to afford it. And if she can't afford it, are there any assets that she can tap into, or will there be penalties? So she's got concerns about liquidity, and I'm going to explain a little bit more about that in a minute. So you can see that I like these pictures. I think it's easier to understand. It's easier for me to understand and explain with pictures. So hopefully the pictures help also keep you engaged in what we're talking about. So there are two main categories of retirement accounts: defined benefit plans and defined contribution plans. So on the left, we can see Bob is receiving a defined benefit plan, and I'm indicating that by the check that shows payments going to him, that arrow. And what that indicates is that in a defined benefit plan, when he starts to receive the benefits, he will get a monthly income for the rest of his life. So this is the type of plan where the employer says to him, when you retire, Bob, we're going to pay you X amount of dollars for the rest of your life, no matter how long you live. This is an income stream that Bob cannot outlive. So it is going to continue for the entirety of his life. And on the right-hand side here, you see that he also has a defined contribution plan. And it's hard to see that that's actually an account statement. But a defined contribution plan is where the employee and or the employer put money into an account on a pre-tax and sometimes post-tax basis, and the money grows income tax deferred until retirement. So it is an account that if you have a statement with an account balance, most likely you're looking at a defined contribution type of plan. Some examples of these would be 401ks. If you worked for a university or a hospital, you might have a 403b. Government employees have 457, but they're all defined contribution type plans. Now, both of these types of assets are marital property and subject to division between the parties. We could spend an entire day or 2 or 3 on the nuances of dividing these assets. The oversights and mistakes that can be made are tremendous when it comes to divorce and dividing up retirement assets. But for this session, I'm going to focus exclusively on critical financial errors that I've seen affect many post-55-year-old clients post-divorce. Okay, let's go back to Karen and Bob. And let's rewind back to Bob's retirement date. So Bob is already retired. We said he's 57, Karen's 55. He's already elected retirement. Now, he and Karen wanted to maximize their retirement income, the check that he's getting every month while they're both alive. So they chose the largest benefit option. So they had different options. One option would pay him and stop upon his death. Another option would continue to pay Karen an amount after he died. They wanted to get the most money they could get coming in cash flow wise while they were in retirement, and they got some advice from their financial advisor that they should choose the single life annuity, which would pay lifetime income to Bob but would stop upon his death. Bob and Karen had sufficient life insurance to ensure that she'd be financially secure if Bob died before her, so they maximized their pension income, and they had life insurance to secure Karen's income needs if Bob died before her. But now they're getting divorced, and Karen needs that pension income to last throughout her lifetime as well as Bob's. The election that they made at his retirement, though, for a single life annuity that stopped upon his death was an irrevocable choice. It can't be changed. So now what? Karen needs to make sure that there's a life insurance policy in place still to protect her if Bob dies before her. Now, once the divorce is final, if Bob owns the policy, how can she be sure that he's making the premium payments and continues to name her as beneficiary? This is where you want to take out your pen and paper and write this down. When I work with clients, I always ask that my client be awarded ownership of the life insurance policy that's securing any sort of spousal support or pension income, regardless of who's required to make the premium payments. So in the overall settlement, you might agree that Karen might agree to make the premium payments, or Bob might be making the payments. But the only person that gets notified if a payment is missed is the owner of the policy. If Karen is the owner, that puts her in the driver's seat of that policy, and it helps her sleep at night because she knows that that retirement income that will stop upon Bob's death, that she has a way to protect herself, and she'll still have income coming in from the life insurance policy to support her financial needs. So that's really important. You want to be the owner and the beneficiary of that life insurance policy. So what is the type of questions that you want to make sure when you're working with attorneys? Which I hope that if you're considering getting a divorce, it's a very specialized area of the law, and it's really important to get a qualified family law attorney. And this is the information that your attorney is going to need to request. One is what is the benefit estimate for the pension at the earliest retirement date? At full retirement date, does it include any early retirement supplements, temporary benefits, or a Social Security bridge? And I'm going to discuss those things in a few moments. And we already discussed the survivor benefit option. So it would be really important. Let's say Karen didn't remember that she and Bob had elected that single life annuity, which would stop upon his death. So it would be important for Karen's attorney to ask, how did Bob and Karen elect survivor benefits on that pension when he retired? And that all of this information should be coming directly from Ford Motor Company. Because even in a case where Bob and Karen are in very good terms, he might not know the different components of his pension. Now, the other type of plan is a defined contribution plan. And as I said before, just like a defined benefit plan, these are also marital assets. Now, one thing that's important to know, and again, this is something good for you to write down, there is no tax due on the transfer of assets between ex-spouses pursuant to a divorce. So I can't just transfer my IRA account to my sister because I think I have a wonderful sister and I don't need the money and I'm going to give it to her. The way the IRS would look at that is I would have to take a distribution, cash it in, pay the penalty because I'm not 59 and a half years old, and then give her the money. They would not allow me to transfer my IRA account to her. However, again, there is no, regardless of whether or not it's a retirement asset or a brokerage account, there's no tax on any transfer of assets between ex-spouses pursuant to a divorce decree. In order to divide up a defined contribution plan and a defined benefit plan, if it's a corporate plan, you need to have a special document called a Qualified Domestic Relations Order, or QDRO, or Quadro for short. Dividing up the 401ks, a lot of clients will come in and say to me that they think that they're getting part of their spouse's 401k and they're expecting the check tomorrow. Well, it generally takes, depending on what expert is retained, most of the cases that we see coming through our office, attorneys farm that out to an expert in that area to draft, and generally costs somewhere between $300 to $500 or $600 to get that prepared, that special document. It's really important that it get entered as soon as possible once the divorce is final. And it's important to know also that if you're counting on that money, you can probably consider that you're not going to receive the actual money for at least 3 months. When you're dividing IRA accounts and you are at retirement age, what you need to do is make sure that that you seek advice from a tax specialist or a CPA about whether or not you need to continue or when you need to begin taking required minimum distributions. If you've been working with a CPA and let's say your spouse or you are over 70 and a half, you know that you need to start taking required minimum distributions out of retirement assets. And that's going to change if you get divorced. You're going to have a new schedule. So you want to make sure that you seek appropriate tax advice. A good post-divorce checklist for dividing up defined contribution plans is to make sure that all the accounts actually get transferred. No one is going to care about that as much as you. It doesn't matter what your divorce decree says. If you're done, your divorce decree can say that you get your ex's 401k, but unless the Quadro is entered and approved and the money transferred to you, you could wind up getting nothing if your ex predeceases you. So you want to make sure that you get that done quickly and make sure that all the accounts that are supposed to be transferred are transferred as soon as possible. Then you want to make sure that you sit down with a financial advisor and you talk about what your new asset allocation strategy should be now that it's just you and your assets need to last for the rest of your lifetime. You also are going to have a liquidation strategy for when you know you can start securely taking money out of your retirement accounts without worrying about depleting them. So I always recommend to my clients when they're done with their divorce case that they go and meet with a financial advisor and talk about what the next step is. We can create the most beautiful, perfect settlement, but if my client leaves all their money invested in cash, when we had projected that they would be earning a reasonable rate of return, all of the planning that we did during the divorce is going to fall by the wayside. Okay, now Karen's third concern, if you remember, was Social Security. She didn't understand how spousal benefits worked, and so this is going to be one of those handy reference tools that you can reference back to if you have questions later on. First of all, you must be married for at least 10 years to your spouse to be entitled to spousal benefits. You have to be unmarried at the time that you enroll. And if you got remarried, your spousal benefit would cease. The way that it works is that you will be entitled, as long as you've been married for more than 10 years, you will be entitled to 50% of your ex-spouse's Social Security benefit. This is not a negotiation point. It is what it is. You'll receive the larger of either your own benefit based on your own work history into Social Security, or 50% of your ex-spouse's benefit, whichever is greater. And Social Security, they will determine that for you. This is, again, not a negotiation point in a divorce. it will be something to be aware of. It will be reduced if spousal benefits are elected prior to full retirement age, which for most people is at this point 66, but that is a moving target. So if you take the benefit early, it gets reduced. If you can possibly wait until you reach full retirement age or even delay later, it's a better strategy. Although, again, I would recommend that you seek specific financial planning advice on that for your own specific situation. But for most people, it's better if you can delay because you have a larger monthly payment for the rest of your life instead of a reduced payment. However, if you need it and you don't have the cash flow to maintain your lifestyle, then you need to take it. It doesn't affect benefits remaining to the other spouse. So you can get Karen can get 50%, let's say, of Bob's Social Security benefit. Bob is still going to get 100% of his benefit. So he gets 100%. It doesn't affect him at all that she's getting 50%. And he won't even be informed that she has applied and that she's receiving benefits. It just it's an entitlement. It's not an actual asset in a divorce, or not treated like an asset. But you can see that there's a discrepancy there. That if you've been married for a long time, if they were a married couple, that full 150% of the benefit would be coming into the house, into the marital home. But now that they're getting divorced, Bob keeps 100% of his benefit, and Karen only is going to receive her 50%. Now, here's a word of warning. If your ex is entitled to benefits but not yet receiving them, Karen has to be divorced for at least 2 years until she can apply for spousal benefits on Bob's record. So that's only if he's entitled, but let's say they were delaying benefits because they got some advice that would be best for their situation. She's going to have to wait 2 years until she can apply. And widow's benefits. So for an ex-spouse, widow's benefits, first of all, can be up to 100% of the worker's FRA, or that stands for full retirement age benefit. So it's a big increase it would be for Karen if she's entitled to widow's benefits. If Bob dies before her and she's getting her 50% spousal benefit, it would be increased to the widow's benefit, which would be double the amount. Not that we want to give Karen a reason for Bob to die before her, but this is just what the law is. She can't receive it if she's remarried before age 60. This is a strange caveat. But as long as she waited until she was age 60, she can still receive widow's benefits even if she gets remarried. So my advice to the Karens of the world out there that might be thinking about getting remarried is wait until you're 60 years old and 1 day so that you can still receive widow's benefits on spouse number 1. And by the way, you can receive Social Security benefits on up to your Social Security benefits can be shared with an ex-spouse for up to 4 different ex-spouses, as long as you've been married to each of them for 10 years. So if Bob had four ex-wives, all 4 of them could be receiving 50% of his benefit, and he would still get 100% of his. So maybe that's one of the reasons why Social Security is having some funding issues. And the next problem I want to go over is something I've seen in far too many cases. So I'm in Michigan again, and many of my clients and their spouses are employed by the automotive industry. So if you've been employed by the automotive industry or any other large corporation, depending on how long you've been employed, it's likely that you might have a defined benefit pension plan. Now remember, that's that lifetime income stream that Bob can't outlive. Let's take him as an example. He works at Ford and has maxed out his salary and his benefits for his department. Ford says, you know what? We can hire younger people in to replace you, Bob, for a lower salary and a lot less benefits. So we're going to make you an offer. If you retire now, we'll let you take your pension early without any penalty. And we're going to even give you an additional amount that's about equal to your Social Security benefit. Now remember, Bob is only 57. He's not even entitled to reduced benefits until age 62. But Ford says, we're going to consider it a bridge to Social Security. Little bridge there. And when you're eligible to receive Social Security at age 66, that portion of your pension will drop off. So that amount in the green box there is going to drop off and be replaced by Social Security when Bob is age 62. So of his $6,200 a month in pension benefits that he's being paid from Ford, only 4,000 of it is permanent. The other 2,200 will drop off, but it will be replaced by Social Security when he crosses that bridge and he makes it over to age 62. Now, Bob took that offer while he and Karen were still married, and now they're getting divorced, as you know. Now remember, Bob is 57 and Karen is 55, and this is a key issue here. So for those of you that might have been dozing off, grab a sip of your coffee. This is an important concept, and it affects way too many clients that I've had come in post-divorce. Now remember, the pension is a marital asset. The entire time Bob was earning it, even though it's in his name, he and Karen were married. And anything that accumulates during the marriage, whether it's an asset or a debt, is considered marital property in our state, in Michigan. Now they decide to divide the pension income equally instead of Bob keeping the entire amount and giving Karen another asset of equal value. It's actually the most valuable asset that they own as a couple. It's worth much more than the equity in their marital home. So a quadro, remember that's a qualified domestic relations order, is drafted to award Karen her 50% share. As soon as it's approved, Karen will receive her 50% share of the pension and the supplement directly from Ford Motor Company. They cut her the check. She doesn't have to ask Bob for the check every month. Sounds pretty fair, right? So of the total pension benefit, that's $6,200 a month, Bob gets half. He gets $3,100 a month, and Karen gets half at $3,100 a month. Now, of Bob's $3,100 a month, $2,000 is the basic pension, and $1,100 is that Social Security bridge, and Karen gets half of both as well. Sounds fair, right? Or is it? So let's fast forward. Now Bob is age 62 and Karen is 60. Bob is eligible for Social Security benefits. Ford estimated a little bit low, and his actual Social Security benefit that you can see in the middle of the screen here in orange is not $2,200 but $2,800 per month. So bonus for Bob, and the supplement drops off because he walked over the bridge and he is age 62, so that Social Security bridge falls away from the pension. So now Bob is receiving his $2,000 a month from the pension. Remember, Karen is getting the other $2,000. They split it in half. Plus, he gets to keep his full $2,800 a month from Social Security income. So his income went up to $4,800 per month. Now let's take a look at Karen. She's 2 years younger than Bob, so she isn't even eligible to receive early Social Security retirement benefits. Her income is now only $2,000 a month compared to Bob's $4,800. So if you weren't paying attention here, you need to go back and take a look at this. This is scary. So Karen was counting on receiving half of the income of the total pension income, whereas now we're 5 years out from the divorce. Bob's income is $4,800 a month and hers is $2,000 a month. And remember, he was already retired when they got divorced and the entire pension was marital. Now, even when Karen is 62 and she becomes eligible to receive Social Security benefits, she isn't in an equal position to Bob. Remember, her Social Security benefit is either 100% of her own benefit based on her earnings or 50% of Bob's, whichever is greater. In her case, due to her low earning history, 50% of Bob's income, Social Security income, was definitely greater than all of hers. So now her income is $3,400, although it's going to be reduced even further than that because she is 62. She's not full retirement age, which for her would be 66. So it's already going to be reduced by about 25%. So she's not even going to get to keep the full 3,000. She's not even going to get to keep the full 1,400 per month. So her income is now $3,400 a month, a little bit less than that actually, as compared to Bob's income of $4,800. And this is for life. Plus, remember, there was a 2-year gap when her income was substantially lower than his. So the question is, did Karen understand this when she agreed to her settlement? Did Bob know that this was going to be the case? Probably not. Nobody thought about this. But this is a scary oversight on the part of the attorneys in this case. And I see this happen all the time. So One question that I get often is, what are the things that are different about gray divorce? And one of the primary things that I always consider in a gray divorce case, if the parties have been married for a long time, Karen and Bob have been married for 30 years, is there an issue here that we might want to equalize their retirement incomes that we wouldn't even consider in a case when the parties were a lot younger? The reason for that is that Karen does not have any time to get back into the workforce and increase her income. They both agreed she would be a stay-at-home parent and a homemaker, and there was never an implication that she needed to return to work. And now, and she's been working inside the house, of course, doing probably the hardest job, nonstop mom. You can tell that I'm a mom, or I wouldn't be adding that in. But equalization of retirement income is something that we don't really talk about in cases unless someone is 55 and older, and then it's a consideration. Again, we can't assign away Social Security benefits from Bob to Karen, but we can incorporate that equalization theory into spousal support and or the overall property division. And the other question that I like to raise when I work with clients is, how do we treat non-standard benefits in gray divorce? So healthcare, I always make sure that when my clients come to me that we work on a budget, and that they're going to give that budget to their attorney to use as a tool to show why they have a need for a certain amount of spousal support. And oftentimes we'll work with the attorney to come up with some different options on what we think is a reasonable amount of support based on the financial need and ability to pay of the payer in cases like this. Now, Karen has got higher healthcare costs. If the Affordable Care Act goes away, she might have significantly higher costs because her insurance premiums may end up skyrocketing. And if she has any sort of health issues at all, we really have to be concerned as we're negotiating a settlement that we take into consideration that if the Affordable Care Act does go away, that we might need to even keep that support that she was getting, the spousal support, as modifiable or open-ended, so it can be adjusted if there is an Affordable Care Act change. And that would be something that she should obviously talk about with her lawyer. I'm not a lawyer, so I can't give out legal advice. I can just give out information based on my experience and help point people in the right direction. And how do we treat benefits in the divorce? So Bob has health care paid for by his employer. Not only does he not have to pay for it, but his health care premiums are paid for. If he was still working, he might have a company car. He might have an expense account for meals that Karen does not have access to. So that doesn't mean that in some ways that's income for him. It also is an expense that she'll have that he doesn't have. So she might have a car payment, but his is paid for. So how do we take that into consideration in the overall settlement? That's another reason why clients will come to a divorce financial analyst and get some help in terms of how do we put a value on some of these non-standard benefits. And if we can't put a value on them, how do we incorporate some parity or equity overall in the marital estate division to take that into consideration? And I always believe that negotiating from a position of knowledge is the most important place that anyone can be in. And I want to leave you with some pictures that illustrate this. So this is Bob and Karen. You can see that this is an example of Bob and Karen receiving a 50-50 split on their marital assets. So on the surface, this looks like a very fair settlement. They split all the assets right in the middle. Bob and Karen both split that pension, which we talked about. He's retired, so they split everything, and they're both pretty much going to be in an equal position, right? But then when you hire a certified financial analyst, a certified divorce financial analyst, one of the things that we can do is we prepare graphs and charts that show this. And what this shows the relative financial health of Bob over a 30-year time period. And we can do it over any time period, 20 years, 30, 10. But it shows what they look like relative to each other. So even though this is a 50-50 split of the assets, and it feels like they should be in an equitable or an equal position walking away, you can see that they're not. And Karen's net worth, which is a measure of long-term financial health for a financial advisor, is your net worth growing or depleting over time? You can see that Karen's net worth is depleting. And by the time we get out to the very end, her net worth is a little bit under negative 2 million, whereas Bob's number is in the positives, almost 3 million in net worth. And you might ask, well, why is that? That doesn't make sense. They both got 50% of the assets. Two reasons. One, we looked at that pension income being different for the two of them. So what that means is Karen has to dip into her defined contribution plan assets earlier. She's 55 years old, so she wasn't anticipating taking money out, but now she's going to have to. So money is going to come out of her IRA later, and then she might be taxed at ordinary income tax plus a 10% penalty for early withdrawal if she takes it out before 59 and a half years old. So she wasn't anticipating that drop in pension income that happened with that Social Security bridge example that we went over. Two, her expenses in retirement are significantly larger than Bob's. She has higher health care costs. Healthcare costs tend to inflate at a higher rate as well as other items. So every year we know that it costs more money to buy stamps and groceries and gasoline. So we usually, as a financial planner, we usually use somewhere in a 3% average rate of inflation that we apply to projections. But healthcare costs inflate at a higher rate, so maybe 7 to 10%. So Karen's costs are higher, and she has more expenses in retirement. And she ended up with lower income than Bob for a variety of reasons. And because she has to start taking money out of her retirement accounts earlier, she starts depleting her net worth, so she doesn't have the time to earn interest on her interest. So what we wanted to do is we will show that this is it's a slightly higher percentage of the marital estate that is going initially to Karen, and we actually gave her, in this instance, we gave her some spousal support to compensate her for the inequality of their incomes being different from pension and from her having to accelerate taking money out of her share of the defined contribution plan. So we came up with some small spousal support amount, and you can see now that Bob and Karen, although Karen is never going to look the same as Bob net worth-wise in this situation because, again, she has different expenses, higher expenses than he does, at least her net worth isn't falling into negative territory, whereas Bob is sailing forward. To Karen, feels like an equitable settlement. So in this particular case, maybe an equal division of the assets ends up being not equitable in the long term without adding in some spousal support. Every case is completely different. Every case has different circumstances, and everyone needs to be analyzed on its own. However, that being said, without having information about what your living expenses are and what factoring in your assets and how that looks for you long term, it's really difficult for clients to make a decision about settling their divorce. So one of the things that we do, again, is we provide that information. And I believe that even if we couldn't get Karen the settlement that would make her line on this chart go upwards, it's better for her to know up front so that she doesn't have any nasty surprises down the road. Better to know, knowledge is power. And even if she wants to agree to a settlement that doesn't turn out to be equitable for her, a lot of clients want to just settle and they want to be done. At least she knows upfront what she's up against. So I hope that you will join me for my next series, my next lecture in this series on divorce, which will be airing 2 weeks from now. And there are 3 different ones. If you have any questions, again, please feel free to email me. There's my email address, and I will respond to emails when I receive them. And check out our website for a schedule of future blogs. We have some great topics that are presented by the other planners here in our firm on other financial planning topics. So we hope that you come back for many more, and thank you for listening.